And let's begin. So to introduce our keynote talk today, I'm privileged to introduce Professor Sam Verboven. He's a professor at the Data Analytics Lab of Vrije Universiteit, Brussel. His research is focused on developing analytical tools and algorithms that take into account the operational context, domain expertise, and business requirements of the application at hand. Specifically, he has been working on causal machine learning and multitask learning in finance, HR, and healthcare. Now, Professor Sam Verboven.
All right, hello to you all. First of all, thank you for those beautiful words of welcome. I feel very welcome here today. And I do think indeed that the subject of today and the talks of today fit very well within this BrIAS forum. So today we're going to have some talks that are indeed very interdisciplinary in nature. We're going to talk about law and AI, right? Two quite distinct fields traditionally that have come together or are coming together more and more in recent times. So I think I've been mainly introduced, and this is probably, I think personally, the most boring slide that I have today, but I've been taught that it is a good start to introduce yourself, or that it's polite to introduce yourself very briefly. So like Nivedita said, I'm an assistant professor at the VUB Data Lab. I'm one of the PIs there. I'm also cross-faculty affiliated with the VUB AI Lab, and I do both fundamental research, so developing novel fundamental algorithms or investigating the behavior of existing algorithms, and I also develop applications. And we're also very motivated to see these applications applied in practice. And then you encounter practical constraints that sometimes inspire us to do novel fundamental research. And sometimes these constraints can be coming from law, right? And it's basically through this application-focused research that we came into contact with such law constraints, and we noticed that there's a lot of research gap there. Things that we don't know yet, things that we maybe should know, and that can translate to optimization potential, to make better, more compliant models. And that's exactly basically the focus of my talk today, to, from the perspective of computer science, of technology, point to what we think is the research gap that kind of requires, per definition, an interdisciplinary perspective to be able to improve from here. So if you want to contact me, my email is on the slide as well. So just to be clear, my presentation, I present the perspective mainly from the AI side on law and AI. And I want to look at machine learning system design of compliant machine learning systems as an optimization problem. Because that's basically what we do from computer science. We look at problems as optimization problems, we look at the constraints, and we try to find the best solution. And nowadays, that's often based on data. But the problem is very highly dimensional. There are so many design choices that you can make, of which the legal implications are very uncertain and that have trade-offs in between. So a very complex, highly dimensional problem. And the constraints coming from law are also, in turn, very complex. One warning before we proceed to the main presentation is that I'm not a lawyer, and to make everything clear, there is some reductionism of legal complexity here, but that gap will be filled after me by my colleague, Professor Lefkowitz. All right, so to first address the elephant in the room, I think we should acknowledge that AI capabilities are incredible and that recent AI advancements have outperformed the wildest imagination of the most of us. If you went back in time about 10 years ago, you would ask, where would we stand in 10 years? Few people would have predicted where we would be. At the same time, what I've put here on the slide is state-of-the-art technology. This was not possible just over a year ago, right? And now, when I look into the audience, I see no one's mouths falling open in surprise that I was able to very easily, from, well, yesterday at home, to generate a completely photorealistic video of an owl dancing to some music, wearing headphones next to a busy highway. No one's surprised. We're all aware of some of these state-of-the-art capabilities that didn't even exist a while ago, right? And there's more capabilities, of course. Automated trading, and there's a finance theme today. Whether it is reinforcement learning based or it is heuristic based, everyone knows that this exists, right? On the more classic side of applications, customer management or, for example, fraud detection, we have more and more personalization because we have more and more data availability and we have more powerful algorithms, more powerful methods. Just to highlight two pieces of work that I've been a part of. So in finance, we have some work using causal methodologies to estimate at the individual customer level the price sensitivity in a mortgage lending context. And also I do a lot of work in healthcare where we have a huge influx of recent data availability in the form of event log data that we can use to mine causal effects from to, at a personal patient level, optimize healthcare policies to really treat for better outcomes with the same or fewer resources. Still, I think this is all very inspirational, but still no one's mouths are falling open here because we're all quite aware that these kinds of things are happening, that these kinds of things are possible or becoming possible in the near future. And that's, I think, a very important realization that also relates to what requirements are from law side, or what the burden is of this novel technology on regulators and on law. So something that I want to link to our awareness of these AI capabilities is the observation that the innovation awareness gap has reduced. Let me see if I can put a laser pointer on the slide. Yes, okay. So a very rudimentary visualization here where we have the square. So we basically have a timeline. On the left-hand side, we have the square signifying fundamental innovation. A lot of time later, there's awareness, and then there's implementation. So what this basically means is this is how it used to go. There was some fundamental innovation. Then over some significant period of time, there was awareness with the general public. But between the square and the circle, it was mostly just machine learning researchers or very specialized people being aware of a recent advancement. Awareness came much later with the general public, with practitioners. And only then, companies started working on implementing these state-of-the-art technological solutions. So implementation still came much later. I practiced this talk yesterday to my wife, and there my wife called the distance between the fundamental innovation and the awareness of novel technology the periods where I was fun at parties. Because I had knowledge of these technological examples that I could show to people at parties, and they'd be utterly mind blown. That becomes more and more difficult, right? And to illustrate this point, I want to give an example that we all know. So I assume that everyone here is aware of the existence of ChatGPT, right? Yeah, I see people nodding. Of course, we've all used ChatGPT, probably. So you're also aware that how it works is that you give some input text called a prompt. This is put through the large language model, and new text conditional on the prompt is generated, right? So now I'm going to ask you a question. Who here was aware that this existed before ChatGPT launched? So ChatGPT is 2.5 years old. Who was aware of the state of the art in text generation 3 years ago? Okay. Who was aware, or do you think this was possible? So the exact prompt and the exact text that we see on the slide, which I think is a very convincing generation of a fake newspaper article. How old do you think it is for the experts in the room who raised their hands? Who thinks, so ChatGPT, 2.5 years old, who thinks this is older than 3 years? 4 years? Oh, so somewhere between 3 and 4 is the guess, I think. Well, let me tell you, this text was generated 6 years ago. And this text, this particular example, made me quite fun at parties for the longest time. Because until ChatGPT launched, the general public mainly wasn't aware, except a few experts here in the room, simply wasn't aware of these AI capabilities, right? And that has changed. Innovation is moving faster. So if we look at the same time period, multiple innovations are now taking place where we would have one slower development cycle before. The awareness is increased, so my time of being fun at parties also sadly has decreased significantly, because if there is some huge revelation, some huge innovation, such as GPT-2, which this is an example from which was launched in 2019, you guys would know basically at the same time as I do, because it gets invented and next day, if it's something about Gen AI, you will read about it in the newspaper and I will read about it in the newspapers. I've maybe heard something floating around at a conference of something coming, but it's no real tangible advantage. So innovation moving faster, awareness is increased, and implementation times have shortened. Because also companies, the moment they are aware of this novel technology, they're already starting to think about how they can implement this, right? How they can actually use this to get value. Because there's this realization that much of these novel technologies can yield tremendous value for companies. So there's a decrease in the gap between innovation and implementation. And this is also, of course, the case in finance. In finance, there's many applications of AI. For example, you have a lot of virtual financial assistants, sometimes powered by Gen AI, popping up nowadays. There's, of course, RegTech. I believe Gregory is going to mention this as well. So regulatory reporting, automation, algorithmic trading exists, and also in the more classic examples of AI and machine learning, you have increasing powerful personalization in, for example, anti-money laundering based on transaction records, customer records, fraud detection, credit scoring, and classic marketing, right? We know this. Because of the speed up of these more and more powerful systems being applied in society, in reality, in practical deployed systems, we are basically affecting society. So we have this society-altering technology that we're applying very soon after its inception in vivo. So we're doing a kind of in vivo real-time experiment on society where we're not really sure of the impact that these tools may have. And then you can think of, well, an application of what's the impact on my child of the recommendations of TikTok, but also discriminatory algorithms, or even a self-driving bus full of children that drives from the bridge. You can think of many very diverse examples right now. And we also don't know where technology is going to bring us. The talk of the town in 2025 is agentic AI, AI that can autonomously automate a lot of tasks that currently humans do, maybe even replace humans at some jobs. And some colleagues would argue AGI is around the corner, artificial general intelligence that outperforms humans at basically any cognitive task. At the same time, we have very limited understanding of the impact that these technologies have on society. We've already said there are many examples, very intuitive, of harms of these technologies. So there is an obvious need for debate, at least debate, on the ethical design and use of these systems. But ethical debate in itself is not a stringent constraint for the people actually developing these systems. That's what law is. Law represents the boundaries we put on this so-called experiment. So we have legal rules and norms, but these rapidly evolving capabilities put into practice bring a lot of regulatory challenges. That's, I think, the main setting for the talks of today. My perspective that I'm presenting today reflects my own perspective from a machine learning side, a computer science side, where we try to optimize problems based on data. Machine learning, I often call it an engineering profession, right? You want to achieve something, you use data to try it, to measure performance, you look at what you achieve and you move on from there. Most of the things are quite testable if we have the data. This is very different from law, because law is very contextual and often is very difficult to test with absolute certainty, or at least, difficult to test with absolute certainty. And then you can say, well, yeah, you can go to court, but that test can be potentially very expensive if you're fined for millions of dollars, right? So let's approach it from my perspective, which is the optimization perspective. How can we optimize our decisions in ML design to land with a compliant machine learning system? This is an extremely, extremely complex and high-dimensional question, but to make this tangible, we'll go with a running example that hopefully makes things more easy to grasp. So let's see if we, yeah, okay. So consider two dimensions of optimization, of design choices that we can make to make things really simple. We have data selection, and there's 3 discrete options that we can take. And there's model design. Also consider 3 different options of design that we can take. Together, they form a grid of 9 possible system designs, basically. Ignoring the law, everything is basically green, which means everything is basically permitted, nothing is uncertain, nothing is prohibited. ML engineers, data scientists, like to test performance of the options and select the best one in the so-called grid search if you want. So without any laws or regulations, we look at what works best. Pluses mean better performance, minus worse performance. So we see that this is the best performing model with a certain combination of decisions made. We will then deploy it perfectly fine, right? This is kind of how we in academics sometimes pretend that reality looks like when we develop novel systems. But if we actually want to see them deployed, we are met with constraints. This is not how reality works. You could say, unfortunately, but it's fortunately both from the side of ethics that there are constraints on our machine learning design, and also from the side of machine learning scientists, because we like constraints. That's where we get our inspiration to develop new tools, right? But as you'll see, the constraints stemming from law are particularly difficult to integrate in our solutions. So there are boundaries to what we can do coming from regulations, and non-compliance to these regulations has, of course, repercussions. And on this slide, you have a couple of recent examples of basically fines and rulings from within the finance industry of violations of GDPR, AML law, anti-discrimination law, leading to harsh fines for financial institutions. So non-compliance for sure has repercussions. So we want to be compliant in our machine learning design. How can we translate this to our running example? Well, simply recognize that some options or combinations of design options are simply prohibited. Others are we're sure that they are permitted, maybe because there are some rulings that are very close in context, and some are quite uncertain. Now, lawyers would probably argue that there's always some measure of legal risk, but we'll just assume that this is the categorization we will go with, right? So in this case, we would pick a different option where we're sure that something, or relatively sure that something is permitted, and deploy that system code from there. Still, this is not the toy example that reflects the realism of the setting that we're confronted with. Let's take a small sidestep to how, in reality, machine learning systems are developed. Now, I'm making quite a reductionist step here, but the key point is based on reality, how it is described in the literature and from conversations with practitioners in the financial industry mainly. So there's a legal distillation of requirements that's at some point passed on to the data science team, after which the main gist of the technical development is done by the data science team, after which it is deployed and there is compliance checking. Of course, this is cyclic. It isn't fully siloed and these teams will interact, but this interaction is quite limited in practice from what we have found. And this translates to our toy example as follows. So before legal analysis, before legal advice, we are not aware of what is permissible, what would be a compliant system, what would be prohibited. All too often, from our talks with data scientists, legal advisors, and looking in the literature, the legal advice in itself is already quite scoped, is already reducing the the solution space, so to speak, of what should be considered in our machine learning design, and is not always fully aware of the full range of technological solutions. So to take a very simple example, so let's assume that from anti-discrimination law, the legal analysis or the legal requirement pushes for removal of gender and correlated features from the system. Now, this represents a particular focus of the legal analysis, which will tell us, well, whether or not these particular design choices are permissible, uncertain, or prohibited. But this is ignoring more technologically intensive or complex solutions where you could maybe still remove gender in itself, but still have the correlated features which may improve the actual performance of the model, yielding better outcomes, but fix the discriminatory issues with model-based fixes. For example, by some adversarial learning based on a fairness metric that's fully legally defensible, right? So the machine learning engineer has to make a choice, or often makes a choice within this constrained focus, this constrained grid. In this case, they would choose for this model, right? But it's perfectly possible that technologically better solutions that are equally compliant are possible. And ignoring part of the solution space is an implicit choice against alternative solutions. And I think that's a very important point. And when we talk to people from industry, then they say, yeah, okay, but we don't consider it. We make the best choice within a limited frame. Okay, but there's potentially, or there might be potential for better solutions that we're just ignoring, right? But it's difficult to know a priori, of course. Until now, we have assumed that compliance is unidimensional. This is, in reality, also, of course, much more complex. So let's take the case as an example of anti-money laundering. For anti-money laundering, multiple regulations apply to the design of a single system. You have anti-discrimination legislation, GDPR, AML legislation, right? Which are all quite complex and impose multiple constraints on machine learning design, all in one system. So we have multiple regulations, and we need to take the downstream impacts into account in our machine learning design. And for that, we need to translate these abstract requirements stemming from the law into specific implementable measures, so technical decisions in our machine learning design. And that's what we call in our work operationalizations, right? And different operationalizations lead to different design decisions, so different alternative systems, so in a sense to different options in our grid of our toy example that we introduced earlier. Operationalization might be still quite an abstract concept after this slide, so to make it a bit more specific and connect it to, well, an example of a regulation. So let's consider the model as personal data qualification under the GDPR. There's multiple ways to handle this, right? You could avoid the qualification through different options at the data level or at the model level. And if you look at this tree of choices, each resulting choice results in different ways of handling this. And so there's at the data level things you could adjust, removing features, aggregating features. There's anonymization algorithms that could lead to perfectly compliant solutions. There's adversarial learning, which is technically more complex, that you could pursue. Also at the model level, certain things you could do, and you could also basically take mitigating measures if you accept the qualifications, so to speak. So all of these options represent different operationalizations, represent different choices in your machine learning design, and it's very easy to see just from this particular qualification under the GDPR that for the whole range of regulations, this search space or this space of different choices is immense. There's so many choices to be made. And how do you make these choices is a very, very pertinent question that is mostly ignored, but this ignorance comes at a cost. Like on the previous slide, if you ignore part of the solution space, you're ignoring the potentially better solutions that reside there. So let's integrate this novel information into our toy example. So right now we have each circle is now 3 circles representing 3 different obligations. And it's not because you're compliant for one that you're compliant to all. And we even know from literature that there are trade-offs sometimes between the compliance for different regulations, meaning that, for example, one operationalization aimed to improve GDPR compliance could degrade anti-discrimination compliance, right? And these trade-offs exist, and they're even observed and described in law literature from a qualitative angle. But really, what do these trade-offs mean in an ML system, and what are the quantitative effects, what are the quantitative trade-offs between their operationalizations, is very, very under-researched. And if we look at the quantitative impact on these ML systems, the closest thing we've got for evidence is looking at the ethics and fairness literature in ML, where they investigate trade-offs between operationalizations of fairness, privacy, interpretability, robustness as ethical constraints, and performance, which is, of course, very, very important because performance is obviously closely tied to the business value or overall value of the system that we design and use. And well, what's the result of all these papers that look multidimensionally at, so basically at multiple of these constraints at the same time, is that across all of these dimensions, which are closely tied to the same operationalizations we would use for compliance, is that there are trade-offs in almost any combination of them. That more stringent fairness constraints could reduce or could have an effect on privacy, and almost always these have an effect on performance. This is a question, a problem setting that almost any business is confronted with nowadays. But there's no clear guidelines from requirements engineering, from software engineering, how to handle this. So in a first contribution that we've made, we've designed a framework or propose a framework to design, evaluate, and select machine learning models under legal obligations. I won't go fully over our solution, but it's basically a 5-step framework that starts, of course, with the identification of legal requirements, but afterwards takes an explicitly interdisciplinary approach in the conversion to operationalizations of these legal requirements, evaluation metrics, which requires, again, intensely interdisciplinary work to ensure not missing these relevant parts of the solution space, like we earlier had observed in our running example. We then formulate empirically testable operationalization sets, so combinations of operationalizations to comply with all the applicable regulations that we can tie to model evaluation, which in turn feeds into model selection and can also be used for legal justification. So this is something we believe is a tool for companies to develop more performant, compliant AI systems. And that sounds great because you can test things, you can test combinations, you can evaluate them, pick the best one, right? But the attentive listener will now say, yeah, that's true. But we saw the example of one small part of the GDPR that has an insane amount of operationalizations already. So isn't this grid of potential solutions not 9 possible solutions like we have here in the toy example, but in reality immense and basically impossible practically to search or to solve? And then you would be right. The attentive observer is always right, of course. So in reality, the dimensionality of possible operationalizations is actually huge. And it is, we can say, yeah, we prescribe this framework and you can test things, but it is too costly or infeasible for companies to explore all the operationalizations, right? You have a given team size, a given operational capacity to do this. Here we represent this visually by the black square, right? And here we think there's a second research gap that interdisciplinary work can and should fill. And that's basically further our understanding of these trade-offs, of this solution space as a whole, so that companies can refocus their efforts to the area where we know generally the best solutions lie. So we can refocus our efforts to be more efficient, to more efficiently develop more effective and still compliant AI systems. So that's the second part where interdisciplinary research is very, very necessary. Because I present here, well, what we should aim at, but the solution is not here yet. It's not fully mature yet, requires a lot of research. Yeah. But I think that the problem setting is very, very evident. And there's very, very little documented research on this currently. So key takeaways from today's presentation: from the machine learning perspective, the problem of developing legally aligned machine learning system requires suitable operationalizations, translations to actual technical solutions with link to contextual legal interpretations to comply with multiple regulations simultaneously. But this is very difficult, and this difficulty is compounded by uncertain trade-offs between dimensions of compliance and their operationalization, and also the performance of the model, which is, of course, very, very important, because the performance of the model usually guides the value that we derive from the model. So key takeaways for the solution: I think two research gaps that we highlighted, with as the common denominator that interdisciplinary research is really required to enable at the company level to design, evaluate, and select machine learning models under legal uncertainty, but also to uncover in the vast array of possible solutions where performant and compliant regions are, so that we want to give companies the tools to cost-effectively find the best solutions for their AI systems in face of legal uncertainty, with compliance and the optimal performance given all these trade-offs. That was the main message of my presentation. I have one more slide, but that's basically a call for interested parties, if you're interested in contributing to our vision and to our future research on this subject, to just talk to me during the coffee break. One of the, we'll of course further the research that we're doing across these two axes, these two avenues of interdisciplinary research, but we also have some ideas for some more applied applications and what we want to work towards for specific cases in finance. So, for example, here is our vision for AML of the future, where we really believe in that pattern sharing between different financial institutions is the future, so that not each financial institution should become victim of the same money laundering tricks or patterns X amount of times before they individually start picking up money laundering. And so if we can develop technology so that we can share these patterns, something that's societally beneficial, without having to share data, that's basically what federated learning would do, then I think we are sitting one step further towards a better society. But again, to get this implemented, there's a lot of interdisciplinary research necessary. That's why it's the ladder figure and you can only go up if you move up on the law axis and also on the AI axis. That was my presentation. Thank you very much for your attention. I'm also very happy to discuss, of course, during one of the social events. Yeah. Let's wait for the mic.
Thanks. That was very, very interesting. So, as an AI researcher, I was a bit understimulated with the 9 dots. So I was a bit curious what concrete examples of these AI systems would be. And I'm asking that in particular because the thing that worries me a bit is that toy example with nine circles suggests a bit sort of a grid search approach to sort of model selection, whereas the systems that I'm aware of are much more grow much more sort of organically in companies where they're adding on one tool after another to a system. So there's much. So yeah, I'm just trying to get my head around whether your whole framework is applicable if the model selection is not really going like okay, we consider 9 models and we choose the best one.
Yeah.
But rather we continue to build better and better versions of the same model that we committed to sometimes 10 years ago.
Yeah, no, that's a very important question. Thank you. So first of all, of course, the development of a model is not something where you linearly go from start to end. You select models, like you say, from a grid, and that's the choice. There's, of course, cyclical behavior in model development where you're continuously making choices, continuously re-evaluating choices and trying to make the best choice. So the grid toy example is not meant to represent a full discrete grid of all the possible choices, but is just there to indicate that there are discrete choices to be made, whether that's at the start, whether that's your full system, or whether that's applied that's applicable or that's applied to a small part of the model development process. So to come back to the example of anti-discrimination, so you want your model to be fair in some sense, and you have multiple choices of how to implement this, right? And as soon as you have discrete choices to be made, you can visualize it as a grid, right? So I'm not saying you should always grid search over all possible solutions, because like I said, that's not possible. But in model design, you make a lot of discrete choices amongst alternatives. And we are offering a framework, a way of tackling this problem and making choices within the discrete set of design choices that we can make. And this is a continuous thing, right? You constantly are making choices, and you need tools to handle these choices to make them compliant. And that's basically what we're offering, a way to interdisciplinary collaborate to get insight into which choices would align better and we should focus on as developers of machine learning systems. There was another question.
How do you deal with time? In democracy, law will change on time, you know. So it's on a fixed time. Sounds good, but every 5 years, the law may change.
Yes, exactly. So legal analysis, just like machine learning design, is not a one-off thing. It's not something static. And in our paper, we also relate this to like circular re-evaluation. Like so if you have a grid of options, this is also not something static. Like the trade-offs depend on current state of the art of technology. So the grid in itself also changes over time. So you need to re-evaluate even when you have systems in place. And again, connect to our current insights based on the literature, which, as I've understood from talking to people in law, is, like you say, also very changing, very, very fluid. So from both sides, there's actually movement, but we see our tool as a way to have these very complex moving trains and join them in a way and get a grasp on it.
And do you think that you will always find a solution?
That's also a very, very good question. Probably no. What we are aiming to do now in our follow-up work is to get a better grasp or narrow down on what exactly we can solve and what we can't solve. Because what we can't solve is often as important as what we can solve. But again, that requires a lot of interdisciplinary, also legal analysis to connect to operationalizations and also like measurability metrics and so on, which is also still a large question in research. So hence also the call, we need to do this research because there's a huge optimization space and we're currently ignoring a large part of it. But it is very complex. Thank you for the question. Was there some?
I thank you very much for the presentation. I was just a bit uncertain on how you check the compliance with the regulations. Is it some symbolic checks, some logical checks, or how do you do that?
Yeah, so that kind of depends, but at the moment, this is a legal analysis kind of question, which I think my student well versed in law can answer probably better than I can during the coffee break.
Okay, thank you.
Are there more questions?
Hi, so I was wondering, what do you think are the biggest challenges in the framework that you proposed? Is it the fact that you're dealing with a very large search space? Is it the fact that, there is additional research needed to choose among these different trade-offs that you were discussing about? Is it automating perhaps the compliancy checking, or a combination of those? What is your view on this?
Yes, so basically all the points that you've mentioned are quite complex on their own. But at a more abstract level, what I see as the main challenge is, like the fundamental merging of these two domains. Like, we want to treat the design of machine learning systems as a computational problem, but law from every direction is kind of resisting this. Right? And we also don't want to force treating something as a computational problem like you can't, if you can't, but we are sure that we can make progress if we look at what's possible in this intersection. But this requires a lot of legal analysis, connection of this legal analysis with what's technologically possible. So I have to keep on hammering on the same nail of a lot of research still needs to be done. And it is a complex question. It is also maybe a very ambitious question, but we really believe it will lead, we're quite sure that it will lead to better, more informed design decisions.
Sorry, one last question again. I think it was very interesting. I was just a bit spooked about the part that you mentioned that machine learning scientists are actually engineers. I agree that there's a lot of machine learning now that has become engineering, but do you think there are no scientific questions to be asked anymore in machine learning?
That's a very broad question, and I kind of want to make the distinction between the science part and the engineering part. So if you have you have a data science team and you want to develop something in real life, part of it, if it's untrodden territory, is going to be science, right? I think having data and being able to do engineering and gather evidence, having something testable based on data, is also part of science. And finding these solutions is engineering, but the testing itself and seeing and gathering evidence to support your design decisions is, I would say, part of the scientific method as well. So I wouldn't just call it engineering. It's for sure a mix of science and engineering, or engineering is part of science, if you will. All right.
Okay, let's thank Professor Sam once again.
Thank you.